Hello and welcome, everybody. I think all of the people who are in the waiting room are just joining, the numbers steadily rising. So just wait a few seconds until everybody's on. Numbers are going up very quickly. Gosh. Okay, I'm going to make a start, if I may. Hello and welcome to this Class Legal Financial Remedies Journal webinar on the subject of conduct in financial remedy proceedings. My name is Sam Hillas KC, and I practice from St John's Buildings in Liverpool. At the last count, we had almost 800 people signed up for this. The numbers are still climbing, and as I'm speaking, we are just breaching 320. It's a fairly astonishing number, bearing in mind the short lead time, which was my fault, to this webinar, which spanned the Christmas break. There'll be some talk of data and statistics during this webinar, so let me add some of my own, taken from a very unscientific straw poll of my immediate circle. Since this event was first advertised by the wonderful Alex Teamby at Class Legal on the 20th of December, 46% of you have been away skiing. 78% of you are regretting lounging around for days in your pyjamas and not starting work until Sunday night. 23% of you regret not spending even more days lounging around in pyjamas. That's my tribe. And 99% of you only awoke recently from a cheese coma. So the numbers in that context are astonishing, but also quite anxiety-inducing as far as me as chair and no doubt our panellists are concerned. But all joking aside, we are absolutely delighted that so many signed up to tune in today, because it demonstrates to us that this issue of the treatment of conduct in financial remedy proceedings is straight out of the gate as one of the hot topics for 2025. Indeed, unless you've been living in a cave for the last 12 months or so, in addition to the various reports which our panellists will be talking about today and in which they've been involved particularly, we've been blessed with some fabulous articles on the Financial Remedies Journal, including two co-authored by one of our panellists, Anita Mehta, along with Olivia Piercy. Is it time to consign the gasp factor to the history books? And N&J, the last word on domestic abuse conduct. There were wonderful articles by Andrew Day at St Ives Chambers on conduct and its consequences, and from Femi Ogunlendi from number 5 Chambers about the current approach to conduct and whether it's in need of reform, and another of our chairs, Nichola KC, along firstly with Harry Campbell, excluding at section 25(2)G conduct, whether it's strikeout or summary judgment by another name, and another one co-authored with Jennifer Lee at Pump Court about the impact of conduct on needs, and quite how Anita and Nick managed to find the time to chase their park run personal bests every weekend is beyond me. But that's not all, because of course there are resources other than the financial remedy journals, so says my script. The panel has had advanced sight, for example, of an excellent article co-authored by Michael Allen at the International Family Law Group, along with Eleanor Lau and Byron Leong from Lander and Rogers in Australia, which compares the treatment of domestic abuse in money cases in England and Australia and discusses the recent Australian statutory reform. And depending on the time available, we'll hope to cover that in this webinar too. And finally, for a no-holds-barred discussion about the problems practitioners face navigating the conduct landscape, can I recommend Anita and Simon Blaine's excellent resolution podcast, in particular episode 3 of series 4, which aired at the end of November and which also involved the very clever Liv Piercy and Geoffrey Kingscote, King's Counsel, and me shoving my oar in. I recommend them all to you, and if you can't find the links by Googling, please let us know. Between them, those articles amount to dozens of pages written and spoken about this subject matter. But their combined page counts pale into insignificance when we consider the page count of the various reports, especially those which have been published in the last quarter of 2024, and upon which we're going to focus this evening. In reverse chronicle order, they are the Law Commission Scoping Report, Financial Remedies on Divorce and Dissolution, that was published in December, which is a whopping 373 pages. And the Fair Shares Supplementary Report, Dividing Property and Finance and Divorce, What Happens in Cases Involving Domestic Abuse, authored by Emma Hitchings, one of our panellists, and Caroline Bryson, which came out in November, which is a more manageable 73 pages, and Resolutions Report on Domestic Abuse in Financial Remedy Proceedings, that was authored by Anita and Liv, published in October, which is a superb example of concision and precision at just 36 pages. Thank you, Anita. We are indeed blessed to have you all on the panel today, as well as the co-authors of those reports, who will, I promise you, save you hours of reading. We have two heavyweight silks, Nick Allen, King's Counsel, and Nichola Gray, King's Counsel, who are on hand to set out the current law and comment on how the various reports might shape the way in which we treat conduct in financial remedy cases in the future. Before I ask the panellists to introduce themselves in alphabetical order of surnames, may I say a few more things. Firstly, this issue can arouse strong feelings on either side of the debate. We know, because Mr. Justice Peel, head of the Financial Remedy Court, has made it clear in N&J that the judiciary considers domestic abuse to be vile and indefensible, and it has harmful and pernicious effects. None of us working at the coalface could take issue with that. But there are divergent views about whether statutory or procedural reform is achievable or necessary or even welcome. Can I make it clear that the panel members have been chosen this evening because they are fully on top of these issues due to their authorship of reports, or they have taken part in recent public debates on this issue? They will be expected to and have been encouraged to consider all sides of the debate, and any views expressed will not necessarily represent their personal or professional views. Secondly, a point about the use of terminology, and with no apology, I'll adopt the terminology in the resolution and the other reports, those on victim survivors and perpetrators. Thirdly, there is the capacity to put questions in the chat box. They'll not be seen by the wider audience, so don't worry, don't be embarrassed if you're going to ask something which you might think is a very simple question. We will try and keep an eye on them, and if we have time, we will deal with them, but the likelihood is that we will have to be careful of not overrunning, so please don't be offended if we don't get to them. And fourthly, the format. The first half of the webinar will consist of our panellists. So firstly, Nichola and Nick talking about a summary of the current law and procedure. Anita, Emma and Christine will then tell us about their reports. And then the second half of the webinar will be given over to a discussion led by questions about where we should go from here, or indeed where we can go from here. So all of that now said, can I move immediately to allow our panellists to get a word in edgeways and introduce themselves briefly, starting with you, Nick.
Thank you, Sam. I'm Joint Head of Chambers at 29 Bedford Row in London. I'm a door tenant at St Ives Chambers in Birmingham. I sit as a Deputy High Court Judge in the Family Division and as a recorder in the Family Court. And I regularly sit as a PFDR neutral evaluator and also as a IFLA finance arbitrator.
Thank you, Nick. Christine?
Oh, hello, I'm Christine. I'm one of the lawyers on the Law Commission's Financial Remedies scoping paper, and prior to that, I was a financial remedies lawyer.
Thank you. Nichola?
Hello, I'm Nichola Gray. I am a KC specialising in matrimonial finance cases. I am Joint Head of Chambers at One Hare Court. I also am an IFLA qualified arbitrator, and I sit as a PFDR judge.
Thank you. Emma?
Hello, I'm Emma Hitchings. I'm a Professor of Family Law at the University of Bristol, and I'm also the Principal Investigator on the Fair Shares project.
Thank you. And last but not least, Anita.
Hi, I'm Anita Mehta. I'm a barrister practicing at 4PB. I'm frequently instructed in cases that involve conduct and some of the issues that we're going to discuss. But for these purposes, I am also the co-chair with Olivia Piercy of Hunters of the resolution working party that wrote the report into domestic abuse in financial remedy proceedings. I should also say I have absolutely terrible lurgy and a very bad chest. So if I suddenly disappear, it will be because I'm dealing with a coughing fit, but I will come back.
Thank you very much. So can we move over now? The introductions are done, and I'm going to move straight to you, Nichola, first of all. If you could set out for us the current law and what the current legal tests are if a party wants to raise domestic abuse as conduct in financial remedy proceedings.
So the law is actually quite straightforward, albeit rather blunt. So the starting point is section 25(2)(g) of the Matrimonial Causes Act of 1973, which is almost as old as I am. The court can take into account conduct which it would be inequitable to disregard. There is no statutory definition of conduct, but it is clear that it can include personal misconduct. That's where a judicial gloss has been introduced onto the statute. So personal misconduct can be taken into account if it is gross and obvious. And in the House of Lords decision in Miller and McFarlane in 2006, the House of Lords confirmed that it was an appropriate gloss on the statute. So the conduct has got to be gross and obvious. And what does that mean? Gross and obvious in some cases has been said to mean it's got to have the gasp factor. So it's something that is you know it when you see it, but it's got to have the gasp factor. So in more recent cases, so for example in OG and AG, that was in 2020, Mr. Justice Mostyn said that personal misconduct is only going to be taken into account in very rare circumstances because it's got to have this gasp factor. The most recent decision on conduct is the decision of Mr. Justice Peel in N and J. That was a decision in July of last year. He made it clear that domestic abuse in all its forms, as defined in the Domestic Abuse Act of 2021, can be personal misconduct for the purposes of section 25(2)(g. But the conduct must have an identifiable financial consequence if it's going to be taken into account under the statute. So there has got to be a causative link between the conduct and some financial consequence. Now, Mr. Justice Peel did recognise that in theory, there might be cases where the conduct did not have a financial impact. But in his words, those cases would be vanishingly rare. So as practitioners, I think as the law currently stands, you have to assume that if the conduct, the domestic abuse is going to be taken into account, that it has got to have a financial consequence. And then finally, the conduct has got to pass a materiality and a proportionality test. So even if the domestic abuse is gross and obvious, and even if it has had a financial consequence, it must still be material to the outcome of the case, and it must be proportionate for the court to inquire about it. Mr. Justice Peel said that in his view, a fair answer would normally be found by the application of the other section 25 factors disregarding conduct. So the bar is high, it's very high. There is no guidance as to how you would go about proving financial consequences, particularly, for example, of domestic abuse in the form of coercive and controlling behaviour. How do you go about proving the causative link? There's no guidance in relation to that. And there's no guidance, finally, if your conduct is gross and obvious and it's had a financial consequence, what do you then do with it? How do you work out what the answer is, having taken it into account? So there's no guidance on that either. But I think the key takeaway is that the bar is high and there's got to be some financial consequence of the domestic abuse if it's going to be taken into account as the law currently stands.
Thank you very much, Nichola. Can I move over to you, Nick, to set out for us, if you could, the current practice and procedure that would be adopted if a party wants to raise domestic abuse as conduct within financial remedy proceedings?
This is all very helpfully set out in Mr. Justice Peel's earlier decision in Savetkov and K. Rover, starting at paragraph 45 of the judgment. The first thing he says very clearly is he deprecates parties who either reserve their position in relation to conduct by putting words to that effect in box 4.4 of the Form E, or recount, in his words, a litany of prejudicial comments which don't, on any view, remotely reach the requisite threshold that Nichola has just outlined. He then goes on at paragraph 46 to set out the procedure that he says should be followed in every case where a party wishes to pursue conduct allegations, whether, of course, domestic abuse allegations or otherwise. First, he highlights, as Nichola has, that conduct is a Section 25 factor and must always be pleaded as such. In other words, you shouldn't and you mustn't raise it as an ambush at a final hearing. It needs to be properly case managed. A party needs to raise their allegations, his or her allegations, at the first available opportunity. And when they do that, and this is really the pleading element of it, should state with particularized specificity the allegations. Second, state how those allegations meet the threshold criteria for a conduct claim. And again, this completely echoes everything Nichola said. Third, identify the financial impact, the causative financial impact of the alleged conduct, because obviously the author of the alleged misconduct must know the case that he or she is being asked to meet. He then refers to the court's case management powers at FPR 1.4, which dovetails the compliance with the overriding objective and court's active case management duty at 1.1, and goes on to say that the court should determine at the first appointment how to case manage the alleged misconduct. And he says that the court is entitled at that stage to make an order preventing the party who pleads conduct from relying upon it if the court is satisfied that the exceptionality threshold required to bring it within Section 25(2)(g) is not made out. He reiterates that set of procedural guidelines in N and J. It's of note that the resolution report states that conduct is the only statutory factor where a process exists specifically to eliminate it at an early stage, and gives an example of where a party was permitted to run special contribution, but was not the obverse of that. The other party in the case allowed to pursue conduct because it was excluded at the first appointment. It has been suggested that the court may have a statutory duty to consider all the Section 25 factors at a final hearing, which may mean it's difficult to exclude such a statutory factor at the first appointment. Wyatt and Vince said a court at final hearing has a meticulous duty to consider all the Section 25 factors, but that argument was rejected by Mr. Justice Peel in his year in review of the Financial Remedies Court, published on the 27th of September 2023. And the other argument that's been raised, which is in the resolution report, is that rules contained in a statutory instrument, Here, of course, the FPR 2010, which allow a court to decide which issues need investigation and which do not, cannot change substantive law unless permitted to do so by statute. And that principle is drawn from Dunhill and Tasker and Bergin, Supreme Court case of 2014.
Thank you very much, Nick. Well, I'm now going to move on to the reports. I'm going to turn to you first, Anita. I know firsthand how hard and for how long you and Liv have worked on your project with resolution. Could you set out for us the purpose, the focus and the main conclusions of the resolution report, please?
Yes, I'm happy to. The resolution report was published in October last year. It was the work of a multidisciplinary team. It included barristers, solicitors, mediators, academics, IFAs, representatives from other stakeholders in this area and charities who work in this area. And it was an effort to pull together all of the different views. The report, the work of the Working Party, started with a survey of family law professionals. And that survey was shared widely at the beginning of 2024. It was shared via resolution and the FLBA, as well as being put on social media. And it was followed by an option for people to submit more detailed comments anonymously. The survey attracted 526 full responses, which I am told is a lot of responses for a legal survey. That's just only slightly more, I note, than people who are logged in this afternoon. But more than 50% of those were solicitors. Resolution also received some direct accounts, again, anonymously, from victim survivors. So what it went to look at was two issues. Firstly, did the professionals think that how domestic abuse and specifically also economic abuse should be considered in the outcome in financial proceedings? So is it sufficiently taken into account in respect of conduct? And then a second point about whether the process from separation all the way through to court order and the court order being enacted protects victim survivors from abuse. So examples of that kind of abuse could be failing to pay maintenance, refusing to allow access to family funds for legal fees, withholding disclosure, frustrating the pressure. So all of the sorts of things, frustrating the process, all of the sorts of things that we see all of the time and is designed to put pressure on the vulnerable party. So we know that type of behavior, sadly, sometimes leads to better results. And what we wanted to do is look at that through the lens of it being abuse, now that we understand that's what it is to be. So in respect to the first of those issues, resolution identified that there was professional concern about the outcomes that are currently being produced. From the respondents to the survey, about 80% said that the long-term impact of domestic abuse and economic abuse is not sufficiently taken into account. I have spent a lot of time thinking about why it is that there was such an overwhelming response from solicitors. And the conclusion I came to is that is because they are the people who are working the closest with the clients, and they are probably the only professionals who have any insight about what happens after the agreement is reached or the orders are made. So resolution concluded the current approach created some outcomes that left victim survivors vulnerable. I should say resolution knew it was going to be the first of these three reports and that Fair Shares and the Law Commission were coming straight after it. So it didn't set out in this report to make final recommendations about what should be done about this. But as a body, it said, well, we support fair outcomes for victim survivors. We also support helping families reach agreement without litigation. And of course, we want to protect our overburdened court system and our judges. So now the powers that be at resolution are going to have to be considering how to achieve all of those aims, including whether there needs to be statutory reform in order to do so. And it would be above my pay grade to indicate what way it's going. The second part of the report is the recommendation about what we can do to reduce post-separation abuse. And as you've already acknowledged, conduct and how it should be treated in respect of outcomes can bring up divisive and different views about what is right. However, what we found is there was practically universal agreement that we could all do better within the justice system to try and protect victim survivors during the process. So resolution engaged with trying to find a series of recommendations that would protect those victim survivors, as well as trying not to increase litigation or the costs for the parties. So that included tackling some of the things that I've already talked about. I won't go through all of the recommendations. One of the points that I found, actually I found a bit of an anomaly, is that in the survey, only 7 out of 10 professionals said that they were concerned about the statutory test for legal services payments orders, whereas in the follow-up work, we found practically universal agreement that the current statutory test is not fit for purpose. And there was frankly concern about people being able to access their own money to get representation and ensure they were able to get fair outcomes. So what it finally concluded is that there needs to be a cultural shift starting from now about how all of us deal with these cases where there are these issues, to ensure that parties are protected from ongoing abuse during their contact with the justice system.
Thank you very much, Anita. Emma, I'm going to turn to you next. Your Fair Shares report, the first main report, which weighed in at another whopping 397 pages, was a tremendous piece of work from you and your team, and the follow-up report focusing on domestic abuse is equally impressive. Again, similar to Anita, could you set out for us the purpose, focus and main conclusions from that piece of work, please?
Thank you, Sam. Okay, so for those of you who are not aware of the Fair Share study, the aim of the research was to provide the first representative picture in England and Wales of financial arrangements on divorce. So up until our study, we knew something from court file surveys about the financial arrangements of divorces involving a court order, but not of the out-of-court population who make up the majority of the divorcing population. So in terms of the main study, we contained 2 elements: an online survey of just under 2,500 divorcees and further interviews. Now, the supplementary domestic abuse report is based on a subset of that main data set. It's based on the responses of 670 survey participants who reported that the abusive or controlling behaviour of their ex-spouse was a reason for the breakdown of their relationship. In terms of the proportion, they account for 3 in 10 divorcees within the survey, and 8 in 10 of whom were women. So in terms of the main conclusions from the supplementary report, I think one of the first key findings was the greater financial vulnerability of female survivors of domestic abuse. Whilst female survivors were far from a homogenous group, on average, they were entering divorce in a more precarious financial position than other women. They had fewer assets to divide than other divorcees, as they were less likely to be homeowners and also less likely to have a pension. Even among those who had a pension, half of female domestic abuse survivors had a low value pension pot, and this can be compared to 1/3 of other women. They were also less likely than other divorcing women to have been working at the point at which they separated, and less likely to have been working full-time. And after divorce, female survivors were less likely than other women to be in full-time paid work and also more likely to be on universal credit. So if we look at all of these elements and all of these findings taken together, this means that their female domestic abuse survivors had potentially less capacity to financially support themselves after divorce, particularly given that domestic abuse was more common among women with dependent aged children. Being poorer and more vulnerable financially makes it particularly difficult for female domestic abuse survivors to get on that path to independent living following divorce. In addition, we found that survivors were more likely to be entering into negotiations about the division of assets and finances with less knowledge about their ex-spouse's finances, which of course potentially places them at a disadvantage during the negotiations. A second key finding we found was the importance of the legal system. First, we found that domestic abuse survivors were less likely to reach a financial arrangement on divorce compared with other women. But among those survivors who had reached a financial arrangement, they had made significant use of formal legal processes, with the majority of arrangements made by both female and male survivors made into a court order at 61%. Now, this was more likely than for other divorcees, where the statistics were at 42% for other women and 48% for other men. Also, among women, survivors were more likely to use contested court proceedings, with what we found was a relatively high 17% of female survivors reporting that their case had been determined by a judge at an adjudicated hearing, and a further 5% settled after financial proceedings had begun. This compares to only 4% for an adjudicated hearing for other female divorcees and 3% settled after proceedings began for other female divorcees. Another key finding was the limited use of mediation. We found that very few domestic abuse survivors had successfully used mediation to reach a financial arrangement. Whilst 16% of female survivors and 13% of other women had attempted mediation, only 4% of arrangements made by female survivors had been made by mediation, compared to 1 in 5, 19% of arrangements made by other female divorcees. That's 4% compared with 19%, quite a difference. Now, the fact that survivors use the court in higher numbers than other divorcees, as well as few survivors coming to agreements using mediation, suggests that many survivors want and need robust judicial oversight and intervention. And the final key finding that I want to draw attention to today is relating to costs and also the limited use of legal aid. Now, although domestic abuse survivors are, as we know, subject to means testing, entitled to seek legal aid for private family law matters if they meet one of the prescribed evidence requirements, both male and female survivors of domestic abuse were more likely than other divorcees to have incurred legal or mediation costs in sorting out their finances on divorce. Furthermore, only 16% of female survivors and 19% of male survivors received legal aid, whilst half of both female survivors and male survivors paid for legal or mediation costs themselves. Therefore, many survivors of domestic abuse are funding their own cases, and doubt is cast as to whether all eligible recipients are receiving the legal aid to which they are entitled. So what I think this final finding suggests is this potential need to raise the legal aid capital and income thresholds for survivors of domestic abuse, in light of the findings that many survivors of abuse are funding their own cases and also the low levels of legal aid awarded to them.
Thank you very much, Emma. I should say to the viewers that we did consider having slides, because there's a lot of information and data there in what Emma has summarised. We decided against it because of the panel format, but all of this, the stats and the data is very clearly set out in the report. So finally, Christine, I'm going to turn to you if I can. You were part of the team responsible for the Law Commission Scoping Report, which is the latest of the reports to have been published just before Christmas. Chapter 9 of that report in particular focuses on the issue of conduct and how it's treated in financial remedy proceedings. Again, like Anita and Emma, could you set out for us the purpose, the focus and the main conclusions from your work, please?
I'll do my best. Thank you. Yes, scoping report on financial remedies on divorce and dissolution was published just before Christmas, so you can be forgiven for not having read it yet. I'll try and explain a bit about it. The overall purpose of the report was set out in our terms of reference, and it was to consider the operation of the current law governing financial remedies and whether it requires reform. In particular, we were supposed to answer a question about whether the current law provides a cohesive framework in which couples going through divorce or dissolution can expect fair and sufficiently certain outcomes. Importantly, we weren't, however, tasked with making recommendations for law reform. It's a scoping report. We've described it before as a sort of a step on the path to reform rather than the destination itself. Our aim was just to identify problems with the current law and present government with a range of models on which potential reform could be based, and they will then either take that forward or not. In conducting this exercise, we engaged with stakeholders, including academics, members of the judiciary, members of the legal profession, and importantly, civil society organisations, including those representing victim survivors of domestic abuse. We had the benefit of the Fair Shares report, providing evidence about how couples divide their assets on divorce, and we also conducted comparative work, looking at how the law operates in other jurisdictions, and whether that could offer any insights into how it might work here, in particular, bearing in mind the social contexts in other jurisdictions. In addition to seeking to answer that broad question of whether the law requires reform, we looked at whether reform was required in specific areas, including nuptial agreements, the position of children over 18, potential limits on spousal maintenance, and importantly, the operation of conduct. I'll refer to conduct in a little bit, but overall, we concluded that the law does require reform. It doesn't provide fair or sufficiently certain outcomes. In particular, we were mindful of the criticisms that the current law doesn't allow an individual going through divorce to understand by reading the statute how their case will be decided. The statute, the Matrimonial Causes Act, doesn't represent the significant developments of the financial remedies law which have taken place through case law, out of judicial decisions, and the discretionary nature of the law means that even if a couple seek legal advice, their lawyers may not agree on what the outcome is going to be. And the majority don't seek legal advice, and so the position for them is even less clear. We thought that those couples wouldn't benefit from the discretionary nature of the system and would not have an outcome tailor-made to them, so they would have the disadvantages but not the benefits. To address this, we proposed in our report 4 broad potential models of reform for government to consider, should it agree with us that reform is necessary. We termed these codification, which would involve incorporating into the statute the case law that is sufficiently settled, codification plus, which would do that, but also would mean that we could look at we could move on to those areas which are still outstanding. So, for example, in the case of conduct, we might look at exactly what can be considered as conduct and the effects the defining of conduct might have, and sort of explore that a bit further and answer some of those outstanding questions. Guided discretion, our third model, would involve bringing in a system based on underlying principles. We looked at the systems in Scotland, in New Zealand, and that proposed by Baroness Deach in her bill. And finally, default regime, similar to those operating on the continent, which would be a much more certain set out version of what would happen. So they represent a spectrum of approaches to reform, ranging from minimal reform in codification to replacing the current law with a defined set of rules under which people would know when they married what the outcome would be. I'm not going to discuss those in detail now, given the time I've got available, and I'm sure you'll all be very grateful for that. On the issue of conduct, which was one of our specific issues, we heard concerns from our stakeholders about litigation misconduct and suggesting that cost orders should be more readily made by those engaging in this behaviour, and arguments also that add-backs should be used more often where there's been dissipation of assets. But the primary focus from our stakeholders was the way in which personal misconduct is treated, and in particular, the treatment of domestic abuse, including controlling or coercive behaviour and economic abuse, and whether this should be more readily considered as conduct, which obviously reflects the wider ongoing discussion on this topic, and we benefited hugely from the resolution report and that of the Fair Shares report generally, and the domestic abuse report that followed. And the views we heard from our stakeholders fell into 2 main groups, which won't be surprising. Some commentators and stakeholders, including resolutions, suggested there should be a greater recognition of domestic abuse. You've heard some of those arguments today. The stakeholders noted that victim survivors were predominantly female, they suffered poor financial outcomes, and they argued that overall the financial consequences of domestic abuse should fall properly on the perpetrators rather than being suffered by the victim survivors, as currently appears to be the case. Conversely, other stakeholders, and this in particular included members of the judiciary, raised concerns about the impact on court resources, the delay and increased delay of any widening of the definition of conduct. They pointed to an increase in cases, which would be likely if conduct would be argued. They talked about a floodgates sort of argument, the need for fact-finding hearings increasing, and a reduced chance of settlement and increasing delays and costs. We also heard arguments, which I think have been mentioned previously, such as those set out in Mr. Justice Peel's decision in N&J. The law can already take account of domestic abuse where it's relevant as part of their consideration of the needs, capacity, earning capacity and resources of the spouses. So it's not necessary for it to be dealt with as conduct. We were told that allowing domestic abuse to be considered as conduct would lead to greater uncertainty in the law because different judges would have different views on what might be conduct and the impact that conduct would have on the financial outcome. We were also told that divorce, making it easier to argue conduct, could run counter to the direction that law had taken with the introduction of no-fault divorce. So it would be bringing in blame, and that there was a policy argument against doing so. Having heard all of that, although we didn't make recommendations, we reached conclusions. We concluded it's open to question whether the current law relating to conduct results in fair outcomes for victim survivors. We noted in particular the Fair Shares conclusions that female victim survivors are in a more precarious financial situation after divorce than other women. We were mindful of the concerns raised by members of the judiciary and others that to widen the definition of conduct, to allow a greater role to be played by domestic abuse would make the law less certain. And as I've said already, the discretion of the individual judge in determining what is conduct and what effect that might have. We concluded that the law would benefit from greater clarity and that it should state clearly what forms of behaviour will be considered as conduct, whether that be personal misconduct or litigation misconduct, the impact that conduct would have on a claim for financial remedies, and the process that should be adopted when making an allegation for conduct. Those are issues which any future project of law reform would need to consider, whether that be a project conducted by the Law Commission or one conducted by government itself in future. Any project would also need to address the key question of how to strike an appropriate balance between the needs of the victim survivor and the resources available to the court, to try and address both of those the concerns that we've heard raised. Finally, in addition to looking at conduct as domestic abuse as conduct, we heard quite a lot from our stakeholders about the ways in which domestic abuse impacts on the victim survivor's ability to engage with the court process itself, actually going to court, engaging with the process, filling in the forms, all of that. We thought these were significant. Although our project is focused on whether the law itself requires reform, we thought that these are issues that are matters of access to justice, and the government should consider them as well in any future project of law reform, to try and ensure that victim survivors, as much as anyone else, can expect a fair and sufficiently certain outcome from the process.
Marvellous. Thank you very much, Christine. So we've heard now from all our panellists in terms of their chosen subjects, and we're now going to move on to the where do we go from here section. And we're going to do this by a series of questions. Given the time, we don't want to keep everybody here all night. We could speak for hours about this, but we're going to try not to. We might not get to all of the questions that we planned, but we'll see how we get on. Can I turn to you first, Nick, and ask you this question? The resolution report makes a number of recommendations in terms of procedural changes which might be made to make the financial remedy process fairer for victims of victim survivors. Which of those recommendations, and it might be more than one, do you consider would bring about the greatest change if resources or the lack of resources wasn't an issue?
I think one of the things we're trying to change is culture, as a number of speakers have already said this evening. And so I think changes to the cost rules in FPR Part 28, so the court could, in deciding whether or not to make a costs order, the list that is set out in 28.37 could include, as resolution recommends, any use by a party of litigation, failure to provide financial disclosure, or failure to engage in NCDR as a form of domestic abuse, as defined in the Domestic Abuse Act. So we all know that the greater emphasis on the need to negotiate openly and reasonably in case law in the last 3 or 4 years has borne results, with judges making inter-party adverse costs orders where satisfied that a party or parties have not negotiated reasonably. That's an example where I think culture has changed within a relatively short space of time. So I would like to hope that if the cost rules were amended as resolution recommends, that could impact on the change in culture and prevent or seek to help to prevent parties from weaponizing the litigation process to continue to perpetuate domestic abuse. I think I'd also hope that if there was an expedited process to convert arbitrary.
Oh, I think Nick's just frozen for me. Is he frozen for everybody else? Oh, you're back now.
I'm back.
Just frozen momentarily, Nick.
Clearly, the Financial Remedies Court didn't like the idea of me having an expedited process, but I think an expedited process to convert arbitral awards to an order of the court, because we all know how parties can drag their heels after an order has been made. And I think thirdly, I'd pick up, well, I think in terms of substance, I've never understood why the court can't make interim lump sum orders. I think that ought to be a change to the MCA. But I'd pick up Anita's point about the fact that if there was a change to LSPO applications, that parties are effectively being locked out of their own assets, and saying that they can only apply for an LSPO if they can't obtain a litigation loan, when so many people fear going into debt, even before you take into account that the interest rates charged by the litigation loan facilitators are now north of 20%. So I think those would be my answers, and those would be my the recommendations that I would say could make the biggest changes most quickly.
Thank you, Nick. That was really clear and interesting. Emma, what do you think about that same question about which of the procedural changes recommended in the resolution report do you think, leaving aside entirely the issue of resources or lack of, which of those procedural changes do you think would bring about the greatest movement?
I think from my background looking at the fair shares data, and also very aware of the majority of the divorcing couples not going anywhere near the court at all. If resources or lack of resources was not an issue, I would support resolution's recommendations to raise the legal aid capital and income thresholds for survivors of domestic abuse, in light of the findings that many survivors are funding their own cases, the low levels of legal aid that are awarded to them. In addition, I would say, following on from our recommendation in the main fair shares report back in November of 2023, there is a high proportion of survivors that are paying their own legal cost. I think we continue to suggest that publicly funded tailored legal advice at an early stage in the process would provide everyone going through a divorce with this requisite information at the right time. And in particular, it would help to ensure that all domestic abuse survivors, particularly those above the capital and income thresholds, would be able to receive some support and guidance. So I think that's where I would go, looking at the entire divorcing population, not just the very sort of court-focused aspect.
No, very useful and different perspective. Thank you. I'm going to move on to the second question and direct it to you, Nichola, if that's okay. The current legal test includes the requirement to prove an adverse financial consequence, as you set out in your summary. The fair shares further analysis of the data concludes that victim survivors are more likely to suffer future financial disadvantage than women who do not suffer from domestic abuse. How far can or how far should the court go in taking that data into account?
So I don't think you will find the data relied upon in an individual case, because each case has got to be decided on its own facts by reference to the relevant Section 25 criteria. But where I think the fair shares data and the reports that we've been talking about is helpful is that it highlights to the judiciary that there might be domestic abuse, and if the test is, has there been a financial consequence, to look at whether or not there has been a financial consequence of the domestic abuse. So it might be, for example, that the debate that we're all having will cause the judiciary to think again about earning capacity and how that might have been impacted by domestic abuse. And it might cause the judiciary to look again, for example, at term maintenance orders and what the appropriate length of the term is. So I think the data and the reports and these discussions that we're all having at the moment is relevant, in Nick's words, to the culture and getting the judges to keep an open mind, as I'm sure they have got, and to review the issues that we're all debating. So I think it's relevant to that extent.
Thank you, Nick. Picking up on what Nicola just said, I mean, do you agree? Do you think the court could make better or wider use of the data and information in the Fair Shares report beyond that which Nicola's commented about?
In short, I agree with Nicola. I don't think any court could determine the case in front of it by reference to the data, because it's not the evidence that is in that particular case. But again, agreeing with Nicola, it shows the judiciary that it is in some cases difficult to establish that causative link. And that's, I think, Nicola's point about reconsidering that aspect of the legal test as the case law develops in the months and years ahead. Both the Fair Shares report and the resolution report highlight that the impact on victim survivors of domestic abuse may not be apparent for years, decades even, after the parties have separated. That, of course, has a tension with Section 25A, which takes into account the foreseeable future. And it's obviously difficult for courts to predict, in that sense, beyond the foreseeable future. But long-term impacts that are not obvious at the time of the final hearing will have, as Nichola says, impact on issues such as when a party will have adjusted without undue hardship to the termination of their spousal periodical payments, the statutory steer to a clean break in Section 25A2. So in short, the more data there is, the more rich the discussion can be, and the more informed judges can be when they make the decision on the facts of the case in front of them.
Thank you, Nick. I'm going to move on to you, Anita, next, if I may. The Law Commission report considers the gross and obvious gasp factor test and says that it would be beneficial for the law to state clearly what forms of behaviour will be considered conduct, whether that's personal misconduct or litigation misconduct. To what extent do you think that the current test, so the gasp factor, gross and obvious test, remains relevant given our increased understanding of domestic abuse and its effects?
So I'm going to suggest this was a rather loaded question for you to ask me, Sam, given I've already written on this topic, but I'll give this a stab. Look, the term, the gasp factor, stems from S&S, which is a case from 2007. So it's now 17 years old. And that case was looking at what should be the impact of the domestic abuse in the relationship on the financial remedy outcome. And it was in front of Mr. Justice Burton. And he determined 22 incidents of domestic abuse and conflict. And it was the wife who was saying the final incident, which led to the husband being convicted of ABH, was conduct that was inequitable to disregard. And the husband said, well, actually, you should look at the 21 incidents before that, because then you will just find that the two of us are as bad as each other. And the judge concluded that the final incident, which, as I said, the husband was convicted of ABH. I think the wife ended up on the bathroom floor with blood coming out of a cut on her head, but not oozing out of a cut on her head, just didn't give the judge the gasp factor so as to make it relevant. Now, what I would say about using that test now is, nowadays, we view domestic abuse through the prism of coercive control. And we know that there is a lot of pernicious, insidious, abusive behavior, which, if you look at it individually, is not going to give the tribunal the gasp factor. But cumulatively, over a long period of time, that sort of behavior can have incredibly harmful effects. So I would say formulations like the gasp factor no longer fit our increased understanding of domestic abuse. I think the more recent authorities, Mr. Justice Peel would rephrase that. He would say that the conduct must be exceptional. It's an exceptionality test. And we know that is a high hurdle when it comes to domestic abuse. Not least because of the prevalence of domestic abuse. So we know in Children Act cases now, they are saying that over 50% of the cases involve allegations of abuse. And the Fair Shares report told us that 29% of divorce petitions at that time were citing abusive or controlling behaviour. So we know there's a lot of it about. Resolution heard examples from more than one professional who was dealing with a case where the perpetrator had been had a criminal conviction against the other party, either for ABH or for coercive control, and those convictions hadn't thought to be relevant to consider to cross that test. And the practitioners who are involved were questioning how that could be fair. So we know from the Law Commission report that a conviction for domestic abuse is very rare. The most recent statistics says about 4% of the reports would lead to a conviction. So if you look at it from that perspective, any kind of conviction for domestic abuse is going to be exceptional. So given those sorts of questions, resolution concluded it can only be a benefit for there to be consistency and certainty. So I see we've only got a few minutes left of our time. I know I'm speaking longer than I should in answer to this question. Had I had more time, I was going to suggest that we play Test the Silks. And I could have given you some examples to see whether the three of you came up with the same answers. You know, does it have to be a GBH as opposed to ABH? What about people who aren't allowed to see their children because of the abuse that they've perpetrated during the marriage? But in light of the time, I can see we're not going to be able to play that game today. So resolution said, look, we need to have, wherever the bar is, and whether you agree or disagree with where it falls right now, there should be more certainty about it. So we're not leaving this issue to be run in front of various different district judges, circuit judges, high court judges in different parts of the country by some of the most vulnerable litigants.
Thank you, Anita. We may have to have another panel, because I, for one, would love to see Nick and Nichola playing some kind of play your cards right, higher or lower, and see which category it falls into. But you are right, we are very short of time, and I know that we were going to discuss the Australia issue, and Christine will no doubt sigh in relief now that we're not going to deal with that. We've time for one more question, and I'm going to come to you, Emma, if I can, which is that for the reasons Anita's already explained, i.e. resolution is a work in progress, and for reasons that Christine has explained in relation to the Law Commission report, neither of those reports made specific recommendations in terms of statutory reforms, in terms of legislative change. What would your research tell you in terms of what legislative change might look like if it's legislative change with the objective of achieving fairer outcomes for victim survivors?
So I'm going to probably give a politician type answer here, I imagine. In the report, we didn't provide any specific indication as to what potential legislative change should look like. And instead, we did sort of pass it over to the Law Commission, to the government, and said it was a matter to be considered. But however, what our data does do is it raises questions as to the extent to which the strict position in relation to the lack of express consideration of domestic abuse remains appropriate, given, I think, our findings in the report is one of relative financial disadvantage for female survivors of abuse during the marriage and also in the years following divorce compared with other female divorcees. So in terms of what the research tells us in terms of legislative change, I would suggest the findings suggest that it's difficult to ignore the poorer financial positioning of domestic abuse survivors emerging from a marriage. And so any legislative change should be mindful of this financial reality post-divorce for female domestic abuse survivors. So my view is always based on looking at the entirety of the divorcing population and the realities that they are facing.
Well, it may be a politician's answer, but it was a very good one. Thank you very much, Emma. Now, I think unless any of our panelists have any burning desire to chip in on any of the other issues that were raised, we will probably draw this to a close imminently. I can say confidently that this has been the absolute best webinar so far of 2025. But I think I can say with equal confidence that it would take an awful lot to beat that. And if this is the standard of the Class Legal FRJ webinars, it's worth keeping your eyes peeled for the forthcoming ones. Can I offer my heartfelt thanks and a gush of praise for our truly excellent speakers? No doubt our viewers will agree with me that whilst we may have known something of this subject before today, the depth of our knowledge will have been expanded and we'll have all learnt a lot. And whatever the latest research or wherever it takes us in terms of statutory or procedural reform, I'm confident that we're in safe hands with speakers of this quality. I also want to thank Alex, Team B. Thank you very much for the tech and her team at Class Legal for making all the practical arrangements. And finally, thank you to all of you for attending. Don't be too disheartened by the early January slog. It won't be too long before Easter eggs are back in Asda and Smooth FM's got Christmas #1s back to back. Thank you very much. See you all again soon.